One thing before we begin, Madam Chair, I just wanted to remind everyone that this is an open meeting. We're going to be recording before we officially get started, but I'll go into that a little bit once we do get started.
I appreciate that reminder. Okay, the time is 10:08, and we will call this meeting of the Texas Licensing and Certification Board to order. Today is Thursday, November 12th, 2020. And we welcome everybody via video conference again. Thank you for everybody joining. We now have roll call.
Chair Sarah Oates.
Present.
Martha Gail Reed Lynch.
Present.
Chance Bolton.
Present.
Clayton Black.
Present.
Rolando Castro.
Present.
Tony Pena.
Present.
Buster Renfro. Stephanie Robinson.
Present.
And Lisa Sprinkle.
Present.
Thank you, everybody. As a reminder, don't forget to, when you're not speaking, to put yourself on mute so that we don't have a background noise and that sort of thing. So I think, Kat, can we just jump right into agenda item number 3?
Sure, I think that's fine. I just wanted to mention that, Mr. Renfro, once he joins, I know he's trying to get on the call right now, but as soon as he does, we could just mention that he's joined the call.
Okay.
But yeah, so agenda item 3, if you want to get started, this is really, want this to be sort of helpful and for you all to kind of get some information and your training and go through some kind of more high level specific topics. First of all, I just kind of wanted to address what this meeting is. It's training. It is a public meeting, although we are virtual. Members of the public have been invited in or have access to this meeting. I think in the past when we've met in person, we've propped the door open and folks have come in and out. With some of our open meetings laws has been suspended, which is allowing us to meet completely virtually. One caveat to that is that this meeting will be recorded and posted to the website, just like all the others. And then just like the other meetings, you do have the option of going into executive session if you need legal advice.
Hey,
You could see.
I've been on time. Nobody's letting me in.
Let the record.
Okay, thank you for your.
Carlos joined us.
Buster, I was just kind of going over this meeting. Nothing, you didn't miss anything exciting just yet. But I was just saying that, there is the option if you need to go into executive session, if you need legal advice, if you think there's something that would be privileged, you'll see that Dion created a separate invite just for that. And as always, if you think of anything, you're always free to call me or email me after the meeting if you have any specific questions. So I guess we'll get started. First thing is I reached out to Steve and he developed this sort of virtual pop quiz for everyone so we could see all your answers in real time. So do we have any volunteers of anyone who wants to go first among the board members? Did we lose anyone? I'm just joking. Just joking. I'm just making sure no one dropped off the call or anything like that.
We sat here like, what?
Everyone, if you didn't have coffee, I'm hoping that might have done the trick for a lot of you. But first and foremost, let's start with some sort of softball topics. I wanted to kind of go over the agency itself. In the materials that we provided in our board materials on page 44, we have our agency's org chart. It's a little bit different than what you've seen before. This actually mirrors the org chart on the TREC side, and I think it really just makes clear the structure of the agency. You can see who our division directors are, who you can contact if you have any specific questions. Their contact info is on pages 33 and 35 if you ever need to give them a call or send them an email. We're here for you if you have any specific questions. So I just kind of wanted to address that.
And I asked Kat to point this out to you simply because this org chart looks different than previous org charts, but it doesn't change anything substantively. In my mind, this simply draws a more accurate picture of TALCB. previous org charts made it look like really the only function was enforcement. But that's far from true. So this is meant to be a more accurate depiction of all of the different functions of the board. It looks very similar to the commission side, and you'll notice that there are asterisks where there are shared services between the board and the commission.
And I will mention, because I've asked for it, and I don't know if this is something that all the other board members have, but I asked for an updated directory occasionally, and it's great. It's got everybody's pictures on it. It literally has every single employee that is in Trek and Talc. So if you need that, you can always reach out to Dion to get it.
That's a great idea.
It's helpful, you know, if you have somebody that says, I have, you know, have a question about education or whatever, then you know exactly who to go to.
Right. And as we go along, you know, if you have any questions, feel free to stop me. I mean, don't just let me keep talking if you have a question. So feel free to virtually, you know, raise your hand or speak up on the line if you have any questions. So going back to, you know, what is a state agency? You know, I don't recall there being really a Schoolhouse Rock song that really was on point with explaining, you know, we've got the bill, conjunctions, but there really wasn't a state agency song, in my opinion. You know, you could think of a state agency as, it's part of the executive branch of government, but within it, it sort of has this weird combination of all three other branches of government. You know, there's the rulemaking function, which is similar to the legislative branch. There's the executive branch. You know, we have Chelsea, our administrator, who administers the rules. And then you all also have a sort of quasi-judicial function. You know, there's a decision process in the contested case hearing. So it is this sort of funky combination of all three branches of government, all in one, all seated in the executive branch of our state government. And with state agencies, they are creatures of statutes, or for some agencies, they have their, you know, their origin story in our Constitution. But with it being a creature of statute, the legislature also dictates the specific powers of an agency. And so, you know, I've kind of touched on the rulemaking power, the power to regulate, enforce, and, you know, the legislature has also dictated the limitations on that power. You know, what is the subject matter that this agency covers? You know, whether there are minimum educational standards, minimum licensing requirements, experience requirements, procedural rules. And I kind of bring this up to kind of dictate or show why is this important, and is with your primary function as policymakers is that rulemaking function. And this is all important is because, you know, what rules you make need to be consistent with our state law, and they also need to be made pursuant to a power that the legislature has granted. So, you know, we can't make rules for plumbers, we can't make rules for accountants. We are regulating appraisers and appraisal practice. And so, you know, what I try to think about how our laws and our rules kind of play together, it really is sort of a house analogy. You know, you've got your state laws that kind of, you know, it's the foundation, it's the studs of a house. Those are your state laws, those are your limitations, those are your borders. And then the rules kind of come in and fill in the gaps. They fill in the details, your drywall. And I'm probably using these sort of house analogies because I'm trying to look for a house. That's a side note, but this is sort of what kind of came to mind. If visually, I think that helps you understand how these things kind of play together, is the rules sort of fill in the details, and sort of how the agencies run kind of further fill in the details, if that makes sense. So, you know, even in my limited time here, we've kind of faced rules where we've sort of been limited in how we can change or amend a current rule. And so if you want to think of it as, you know, your walls being your borders, you really can't go beyond that unless there's a change in the legislature. And so I'm hoping that kind of illustrates how the laws sort of interplay with each other, and rulemaking and your functions as policymakers and making rules.
So Kat, I do have a question about that. When you said, you know, we can't make rules about plumbers. So where is it at the top of 1103 that gives us what our sort of scope is? Is that where that is? Okay.
Yes, and you can see, and I know in the table of contents in your board materials, it has the subtitles sort of highlighted. And there's there's a specific section that goes board members and their roles, how they're chosen, but then there's also subsections that relate to specific powers and the rules that you have, to make licenses and kind of makes that scope of the rules. So that's where it is correct in 1103. I think one thing that makes this agency interesting is we sort of have that interplay with the federal law also. That's sort of another layer of the House that I think is distinct from other agencies. There's been a delegation at the federal level where states on their own can regulate appraisal practice. A little bit of that framework also. Maybe they're not, giving you your floor plan, but they're saying, the ceilings need to be so high. There's just, whether it's, you see it a lot in minimum standards of education. There's just little things here and there that they've set a minimum requirement. But other than that, state, you're sort of free to kind of go and fill in the details of what works best for you in your jurisdiction. Another federal component is there is still that monitoring aspect of how our agency runs, and all state agencies are run for appraisal practice. There's regular sort of monitoring, making sure that the process we have in place is consistent with their laws and their rules and those minimum standards. So I think that's important to keep in mind, again, with the rules is, it's not just state law. There's also this federal component that might be either limiting or reasons why, certain numbers or certain standards are set at where they are. I have your video feed to my right, so if you see me looking to the right, it's because I'm seeing if anyone is looking like they're about to ask a question or something. So just wanted to make sure that was clear. Does anyone have any questions before I kind of move on?
I don't know. I don't want to step ahead of you because you might be heading this direction, but sometimes when we're looking at stuff, it will reference other statutes, Texas statutes, and that's kind of where I start to go like, okay, obviously the 2001, the administration code is one, but it would be impossible really for us to know everything that plays into what we're doing in the sense of when we talked about mortgage fraud, that's in a whole other section of statute that I don't even think is referenced in 1103. And then of course, TREC has, some powers over the agency that aren't in our statute, but certainly dictate what it is that we're able to do. And so is it just a huge web that is never ending? Is that sort of how it is? Because at one point I thought, okay, well, I want to pull all the statutes that sort of dictate the things that we do. And then at some point I figured, oh, I don't think that there's an end to that. I think it's the entire, every statute in the state of Texas, so to speak, plus the federal. Is that correct?
And you're correct. And what I was kind of going to go into next after we sort of touched on substantive law was sort of the laws generally that affect all state agencies that I think kind of encompass what you were mentioning. It is pretty broad. I mean, I don't think it'd be helpful to include every single reference in our guidebook just because it comes up when it comes up. There's laws specific in the occupations code that kind of generally applies to all licensing agencies. And you're correct in that, the Administrative Procedure Act, that's something that's going to affect all agencies. And so, it's a little bit of, I guess, job security on my end is just being mindful of all these things that you don't necessarily need to keep in front of you at all times. It's just, a situation just kind of, you know what laws are being implicated when it comes up. But you are correct. This isn't what we discussed today won't be the exhaustive list of laws and legal schemes that are going to affect what you do. There's the ones that are substantive, and there's other ones that will apply to all state agencies or will apply to all public officials, if that makes sense.
Are you following a certain page on the training material? that I can go to? Or,
Not specifically. I'm just kind of talking generals. I've got a couple of page marks or pages written down
okay,
as we go through
I just want to.
that I can kind of direct you to.
Okay, thank you.
All right.
And
Did
so
any-
with regard to other state law that might supersede ours, if there's a statute change, that's what Ledge Council is doing. Is that correct? They are making sure that whatever we're writing that might pertain to rules doesn't violate any rulemaking statute somewhere else. Is that correct?
You mean when kind of the governor's office will weigh in, or
If we're making a statutory change and it goes through Ledge Council before, like I know that the bill is written and then it goes to Ledge Council and there's always some tweaks that come out of that. And so I don't really know what that process is, but I'm assuming that's where they make sure that anything that we're writing doesn't conflict with other. Is that correct?
Yes, it's legislative council is basically a service provided to the legislature. So it does the technical writing work for both, for the House and the Senate. So when we do agencies, associations, others could write a draft of a bill and hand it to a member of the legislature and say, we think this is what it needs to say. Then part of their internal process really is to send that to Ledge Council and have it turned into, this is not the right term, but something more official and kind of plug it into their system. And there are many lawyers that work for Ledge Council that examine that language and make sure it's consistent with their policies of how to draft law and, look for conflicts and that sort of thing.
Okay.
So it's basically an internal legislative process.
And then for our rulemaking, then that you're sort of the first catch-all for that. And then it goes to the governor's office that they take another look to make sure that we're not violating any of all these other web of laws. Is that correct?
correct? I mean, I think at every level, everyone's looking at, do we have the power to do this? Are we in conflict with sort of any minimum standards out there? The governor's office, we talked about the regulatory compliance division and who already, the budget and policy division, I believe, they already look at our rules. They already are looking at whether or not what we're doing is pursuant to, we have the power to do that. There isn't anything so unclear in the rules. And then also, with the regulatory compliance division, if it's something specific to interfering with the free market or, barriers to entry, they have a specific eye to that. So, in many ways, you guys are a lot of the early stages of the process to see if we're running afoul of going beyond our borders. We're looking at it, staff's looking at it, and then there's all these other stages of the process. And then the notice and comment part of rulemaking also is another way that, our rules are being.
So anytime we make a rule as a board, it goes through you and then it goes through the governor's regulatory and compliance division.
No, it not. The regulatory compliance division is very specific to if it has a market sort of effect.
Okay.
But their budget and policy, they get a copy of our agendas. They get a copy of any rules we're proposing well in advance of our meetings.
Okay.
So the budget plan, I think it's either budget and policy or budget planning and policy. Sometimes it changes. And that division within the governor's office has a liaison that works directly with us. So that's our point of contact for all sorts of things. And so that's the person who we send our agendas and all of our rules to.
Okay.
And then for us, it's a gentleman by the name of Chris Smith. And then he will pass that. Sometimes I think he passes them to someone in their general counsel division and they talk about them internally. They have a process and then he'll come back to us and say, yes, you're good. Or we have these questions. So he's there for everything.
Okay.
And then regulatory compliance only if there is a market effect on our rules. It's a second catch.
Okay. Thank you.
But they work really there, Stephanie. We actually had a call with them this week, Kat Chance and I, about something that they saw on our agenda in one of our rules. And they're really great about trying to figure out what our intent is. You know, they don't just look at it and decide one way or the other. They ask us what the intent is, and they try and help us get to where we're trying to go. You know,
Okay. I think moving on, I think there was a printer that was taking the mic for a minute.
Did anyone else have any other questions before I move on?
I won't stop you this much, I promise, Kat.
Oh, it's fine. You know, this should be a time of discussion. You know, it's for your benefit, and I want you all to feel comfortable asking questions. You know, I may not know the answer in the moment, but, you know, I'm happy to come back with answers for you at another time. So, you know, feel free. This is more relaxed discussion based. So again, I want you guys to feel comfortable about asking these type of questions. And they've been really good questions, so I appreciate it.
Rolando? Let's see. Are you on mute?
I was.
Oh, hey, honey, I just wanted to tell you, when I first started with this board, like, this was everything for me. This workshop session, like, I dug in deep. So really, when she says ask questions here, like, this is when you dig in, when you don't understand. So
Absolutely.
the question is a dumb question. Trust me, I've asked them. So
I'll have to look up those previous videos so I can just avoid those dumb questions, I guess, and make myself
really,
look a little bit better.
but as a newbie, seriously, dig
Absolutely.
in. This was so helpful for me last year.
Well, glad to know that.
Yeah.
Rolando and I had a one-on-one, so we're not just throwing him completely in the deep end. He has a little bit of background, but all right. So, you know, we'd gone over some of the substantive law, and now I kind of want to touch on some of the laws that really affect all state agencies everywhere. And the first one I wanted to bring up is the Administrative Procedure Act. And in our materials, we focus on it on page 14. And what the APA, you'll hear Administrative Procedure Act, it's APA, interchangeable. You know, these are basically uniform rules that govern state agencies, administrative law. You know, you can think of it similar to in the civil litigation process, you have the rules of civil procedure. In crim law, you have the rules of criminal procedure. And here, these are kind of our rules of procedure specific to state agencies. And what these rules cover are rulemaking, case process. Now, I'm not going to go into too much detail over the Administrative Procedure Act just because every time there's a rule, you know, we're kind of going to be going through this process. You know already that we propose rules, they're out for a comment period. You know, people can weigh in, stakeholders can weigh in, maybe the language will shift, maybe it doesn't, and then we move on to adoption. You're going to see this process all the time, and if you have any questions along the way, you know, feel free to ask. The other aspect of the APA that touches on is that contested case process, which is essentially bench trials that go to the State Office of Administrative Hearings. You'll also hear that be referred to as SOA. It's basically a courthouse where all administrative or most administrative contested cases are heard by, they're referred to as ALJs, administrative law judges, and they're essentially bench trials. And you know, they issue a proposal for decision, which in many ways is similar on the civil side. If you're familiar, is like almost, you know, a judgment. And then it comes before you and you weigh in on it. And, you know, there's specific grounds for you to make changes to it. And then the process can be appealed further on in district court. And so that's really what I wanted to cover on this, just because, like I said, this is one of those things that you'll see again and again, and you'll get a better understanding as we go along. Did anyone have any questions before I move on? Okay.
I had a quick question on that
Sure.
one. I'm sorry. When we as a board, let's say, make a change on a rule that was ruled in a judgment, does it go back to that same body there and then come back to us as the rule change, or is it taken back somewhere else, or how's that?
Do you mean an actual rule, or do you mean like a contested case?
A contested case or something. If it comes to us and we're we're kind of deliberating and we want to make a change, does it go back to, or is our rule that the change is made, is that what goes forward? How is that?
Typically, if it's your final, if it's the board's final ruling, it's just appealed by a court and it moves on to them. It's moved on to the next stage of the process. It doesn't really circle back. It moves forward. And that's just kind of the nature of the procedural process of a contested case.
Okay.
And that applies to every state agency.
Excellent. Okay.
Although maybe I'm reading into Rolando's question differently. I'm thinking of the case where we had the guy who came in and the ALJ had said whatever the discipline would be, and we changed it. We had the ability to change it, and then it didn't go back to ALJ, correct?
Correct. And that's what I think what I was sort of saying in that your final order that you signed off on is that's after you've kind of tweaked those changes. There's still an ability to kind of make some changes when you get that proposal for decision, but after you've signed a final order, the agency has lost jurisdiction, and what that licensee, the respondent, their next stage of the relief process on their end is to appeal to district court. Okay, so the next kind of area of law I wanted to touch on, and I'm going to focus a little bit more on this one, is the Open Meetings Act, and that starts on, I believe, on page 16 in your materials. Just double check. Yes, it's on page 16. So the Open Meetings Act, starting with the purpose of it, really is that enables the public to have access to the decision-making process. It increases public awareness, and really just gives them an opportunity to see how the sausage is being made. The origins of it, or why we have such a robust area of law here, is rooted in, scandal and bribery. And so that's sort of what this is sort of addressing, making sure that the process is open and people know what's happening and nothing's happening without the public's knowledge. So the first thing I want to get into with the Open Meetings Act is sort of the notice requirement that's involved. Today is an open meeting. There was notice posted, and also our agenda was posted. So the notice requirement and where you guys going to talk about. There's certain deadlines that we have to follow with the open meetings, with posting where and when. The Secretary of State's office has to post notice at least 7 days. And so, this notice part isn't as important for our regularly called meetings, for our quarterly meetings, because we know well in advance when it's going to happen. We're not really at risk of running afoul of not posting early enough. It's when things that don't seem like meetings then become a public meeting is where we run into issues, because unless you've got a time machine, 1.21 gigawatts, what have you, you can't go back in time and post notice. You can't go back in time and let people know what all you are going to discuss. So these are the two main components that I'm going to focus on here. Going into the notice requirement as terms of content, this is sort of where, why we have the descriptions that we have in our agenda items. There's a sufficiency requirement in the notice where, you have to let people on notice exactly what you're talking about, but you can't be too specific that, when a conversation naturally sort of goes to and from, or like goes beyond, if you're being too specific, that you're actually talking about something that you didn't give everyone notice about. So it's a little bit of a, Goldilocks and the Three Bears approach of not being too specific, but also not being too broad where, it's so vague. So we're never going to have an agenda item that's just new business. I mean, that's just too vague. I mean, it might be a header, but we've got sub descriptors that sort of talk about or list out and describe what you all will be discussing. And I kind of want to bring this up because, if we're in meetings and you ever see us sort of redirect the conversation, or, maybe, we didn't really put this on an item to discuss, it's because of this. It's because you will run afoul of not providing the public enough notice of what you all were going to be discussing. So I just wanted you to keep that in mind, but it's all, it's helpful we're here for you to kind of redirect the conversation, but I think it's also helpful for you all to know that this is a barrier for you all. This is something that, you know, we can get in trouble for. Did anyone have any questions?
Well, I'll add to that too, so that you have some context, Rolando, that Kat and I start talking about the agenda a couple of weeks before the meeting takes place. And we try and think of anything that might come up. So where could any of these sub conversations lead to another conversation? So that because of the requirements of posting it publicly, we have to make sure that we have that. So sometimes what's happened when I first started, I remember we would start talking about something and it was like, oh, well, that's too late to add it to the agenda. And that tends to happen because as we lead up to board meetings is when we all start having a lot more conversations and we have our committee meetings and things like that are happening. And so now we're trying to push the committee meetings forward a little bit so that we don't keep running into that, oh, well, now we've waited so late to make that happen. But Kat and I do try and talk about what are all the things that could come out of that. In fact, sometimes if we do have a late committee meeting, we will even look at that agenda and say, is there anything on this agenda that we think we might talk about at the board meeting, and we'll put it on there. And then if we don't need it, we don't need it, but at least we've posted notice of it.
Absolutely. You know, we can always pass an item if it's not really ripe for discussion, but we can't retroactively add one in and not have put enough notice beforehand before that happens. So,
Okay,
you know,
so I'm sorry, one question about the agenda. Like if it's on the agenda, does it necessarily mean, I think that's what you said, is you can pass on it, you can go past it and not talk about it at all?
correct. There is an opportunity to do that. And that's what Sarah was sort of illustrating. You know, if we have scheduling issues with committee meetings, we know something's likely to come up. We're not exact. You're better off discussion, then we can pass that item for a later date.
And it's just something that you have to acknowledge, say, yes, it's on the agenda, but we're going to pass on this item and
Correct.
just go on. Okay.
And a good example of that is the Attorney General's opinion. We keep leaving that on the agenda in case something happens the day before the board meeting that is germane and we want to talk about, but we know that they're not actually supposed to, get back to us until, the next few weeks or whatever.
Right. I've seen that on the last couple. Yeah. Okay.
So the purpose for that is to provide notice to the public on what you could be discussing. So you could be overly inclusive and then decide against talking about it. But if you don't put something on the agenda, then you haven't provided notice to the public and therefore can't talk about it.
Kat, can you talk a little bit about the quorum and when we as board members can get together? Like, because if we're together, say 3 or 4 of us chatting, like, can you talk a little bit about the difference between us doing that and the difference between, hey, you guys can't discuss certain items? So just so that's clear.
And you have perfect timing because this really was just what I was about to get into.
I'm a moderator.
Well, I think that's good, and it could be bad depending on who you are, but it's good in this situation. You brought up a good point about a quorum. Does anyone know what a quorum is?
5 members. Right?
Thank you. Very softball question. Stephanie gets 10 points. So I'm going to share my screen really quick, and this is really just to show you the definition. We know what a quorum is, but I wanted to get into the definitions of deliberation and meeting. So if you bear with me just 1 second. All right, can everyone see that? Large it or anything?
Let's get.
I can see it.
Okay, perfect. So here we have the definition, and for everybody, it's not included in materials. I think there's definitely a link to it, I think, but this is section 551.001 of the Government Code. This is part of the Open Meetings Act. And here we have the definition of deliberation, and it means a verbal or written exchange between a quorum of a governmental body, or between a quorum of a governmental body and another person concerning an issue within the jurisdiction of the governmental body. So, you know, I've highlighted what I think are the biggest takeaways from the definition. It could be verbal or it could be written, and it has to concern an issue within your jurisdiction. It could be between just the quorum, or it could be another person and the quorum. And, you know, concerning an issue with jurisdiction, are we talking about restaurants? Are we talking about ice cream? I think we all know the answer is no. You know, we're talking about the area of appraisal practice. That's within this agency's jurisdiction. Buster, I see you have a question. Your hand's raised.
Yes. Can you hear me, Kat?
Yes.
Okay, so my question is related to the quorum. I know that it's 5 for the overall board, but how does this come into play for committees? And when we're about to have a committee meeting, or we're actually having a committee meeting, and the discussions that go on in and around that?
Right. So a quorum of the board is going to be 5. A quorum of the committee, they're 5. Their 3 members would be 2. And so I'll get into a little bit more detail of, you know, if your question's more to, you know, what happens in a committee meeting if that we ever run afoul of that become a quorum of the full board. I'll address that in a second, but does that answer your question as far as what it means at the committee level?
Yeah, I'm like a little bit more discussion about what kind of conversations, or when is it, and how do we control our conversations in and around a committee meeting when 2 members make up a quorum, or even written emails? How does this issue play into that?
Well, you know, generally our committee meetings aren't going to be a public meeting, and the big reason for that is we don't have a quorum of the full board. Now, where that might change is if a committee, their action ends up being is actually a final action by the full board, and that really happens if, you know, what a committee does is routinely rubber stamped by the board. You know, if it's still kind of this idea, or, you know, this thought process of coming out of the committee and it's still taken before the full board and you guys are discussing it and vetting it, that, you know, that's all fine. But if it's, you know, I think some of the case law and examples are more of in the context of, you know, either hiring an individual or something, or recommending someone, and they were automatically rubber stamped every time. Each time that committee was made a recommendation. That's the sort of issue where it can sort of flip to becoming sort of an action of the full board based on the actions of a committee. So generally speaking, at the committee level, you have less than a quorum. You know, if it stays sort of a closed conversation there, you're not going to run into any issues of that being a meeting.
So that means, and let me just say it this way, and Pat, you can tell us if this is right. Most of the time, it's not an issue to talk about the quorum of a committee, as long as what you're doing is a recommendation to the full board. Because if you're only recommending and then the full board makes that final decision, then it's the quorum of the full board that matters. So if you really, probably the only way, the only practical way it comes into play is whether or not you can vote on that recommendation. Do you have a quorum to make that recommendation? But that's a different topic. That has nothing to do with, you know, whether or not you can or cannot deliberate. Did I say that right?
I think so. But Buster, did that answer your question, or does that clarify anything for you?
Well, yeah, it does clarify that. I think my concern was this. 3 members make up a committee, and in my experience of serving on the board, I can't recall a committee's recommendation coming before the board, and the board, we have tabled some recommendations for further discussion, but I don't recall the board ever rejecting a recommendation out of a committee. So in essence, I don't want to say we rubber stamp them, because most of the recommendations are founded and vetted and thought through, and they make good sense. But I was a little bit more thinking of the issue of where you might get an issue That's a little bit controversial, and you may have two of the board members who are on the committee may see it one way, and there's this third member who's in opposition maybe to this issue. And conversation being carried on by two of the committee members and leaving the third member out. And issues like that, that's kind of, maybe that's not related to the quorum, but I always felt like if two committee members are discussing something and leaving out a third, that there's something going on there.
I think, you know, and this is part of this discussion, and Chelsea and I were talking about it, you know, it's having that discussion in an open meeting or some of that discussion carrying over, you know, it's a good thing. You know, that's how these statutes have been written, to kind of encourage that public discourse and, you know that these decisions are being weighed, all the different interests are being sort of represented, or, you know, issues are being spotted. And so, you know, I think maybe that just goes to a bigger conversation of, you know, making sure you all are aware that you can have this type of discourse in a public meeting, or that, you know, I think the committee structure is sort of designed to be more efficient. Like maybe there's people that take a closer look and you take it to the full board, but there's still, I want you all to feel like there's still a mechanism for you all to have sort of that discourse at the bigger board meetings, you know. Does anyone have any other questions on that? Okay, so we went through the definition of deliberation. So we know what that is. We've got, to boil it down, we've got a verbal or written exchange, we've got a quorum, and then it concerns an issue within the jurisdiction of the governmental body. So now I want to scroll down to the definition of a meeting. I'm happy, I know I'm just kind of sharing my screen right now, but I'm happy to forward you all any of these statutes, or if you feel necessary after the fact. But so here is our definition of a meeting. We've got deliberation again, we've got a quorum, or between a quorum and another person. And then we've got the sort of the nature of discussion, which is something of public business or public policy. And here we have, you know, this topic is either being discussed, considered, or during which the governmental body takes a formal action. So this should all seem pretty familiar to all. This is what happens at our meetings. You know, we've got a quorum, there's deliberation, there's discussing, you're considering things, and maybe you do, maybe you don't take formal action. Formal action isn't required for there to be meeting. You just have to simply discuss or consider. So this is one definition of a meeting. The other definition, I'll scroll down, it's very similar to A, but it's kind of piecemealed out. Here we have a gathering, you know, that is conducted by the governmental body. That seems very familiar. We have a quorum again. And then the meeting has been called by the governmental body. And here on subsection small Roman numeral 4 is that which the members receive information from, give information to, ask questions, or receive questions from any third person, including an employee of the governmental body, and about public business or public policy over which the governmental body has supervision or control. And so I think that the biggest takeaways here is there really doesn't have to be any sort of communication between you all to satisfy this requirement. You all physically just have to be there and simply receive information. And this is how, you know, why, you know, very innocent, you know, we're not talking about public policy or anything, can very quickly flip to, oh, that was a meeting, we didn't give notice, we are now in violation of the act. And so this is, you know, this is why, you know, you might hear me talk about reply all emails where it's very innocent, you know, we're just talking about scheduling. But if I see a reply all, you know, you could just be saying, okay, or, you know, 1 o'clock works, but regardless, it still sends like a bit of panic down in everyone's mind of what's going on. You know, don't be deliberating, careful what you're talking about. And this is important for you all to know, to be cognizant of it, to be cautious. And, you know, we're all have to keep everybody in line and make sure that we don't run afoul of this.
And I would just say, as a bright line rule, don't use the reply all or email to a group of a quorum, so you plus 4 other board members in any instance. Just because what you're doing is creating a document that will later be questioned, whether or not you're talking substantively. If you want to talk about a dinner reservation or something like that, just do that on another media.
Correct. So, well, I hope I've kind of scared you all a little bit. This really is one of those, it shouldn't be DEFCON 1, but it should be set a little bit of alarm bells. It's pretty close of the level of panic that should be going through your minds. So while we've kind of gone through how quickly something can, let's talk about like what's okay, what can we do? Social gatherings unrelated to public business is fine. Going out to eat, if you all remember what that's like, that's all fine. If Martha Gale wants to invite us all to El Paso for a party, and we're not talking about public business, that should be fine. But as we went through the definitions, you can see how quickly it can become a public meeting. There is case law out there where there's a governmental body, 3 members, during a break between meetings to go to the bathroom, and they happen to just start talking about public business. One of them might just make a comment of, that fine seemed too excessive. And the other one's like, yeah, I agree. That's a public meeting that needs to be done in the open. And so this is just how kind of quickly things can become not okay. And so back to the things that are okay, social gatherings are fine. Conventions or workshops, recently we had the Aero conference. There could have been all 9 of you there. You have a quorum, and anything that you're talking to, it's incidental to the subject matter of that nationwide workshop. So that's fine. That makes sense. That's allowable by the Act. You can also attend ceremonial events or press conferences. Those are things where if a quorum happens and any sort of discussion is sort of incidental, public business discussion is incidental to why you're all there, that's fine. We touched on committee meetings already. Generally that's not subject to the Act, but again, if it's sort of that rubber stamp scenario or where it is truly a final action happening at that level, then that is subject to the Act and should be noticed. Next, I kind of wanted to get into our closed meetings, or we'll call this executive session. Those are the same things. There's really only like a very limited subject matter of when that's okay or what you can discuss in executive session.
Kat, can I interrupt you just real quick? Just
Absolutely.
I want to tell the other board members, I typically sit in on committee meetings, even the committees that I'm not a part of. So if, Stephanie wanted to sit in on budget, then we would have a quorum, the 3 members plus me plus her. And so if there's ever anything that's going on at a committee level, I know, sometimes Buster is interested in what education is doing, or maybe Stephanie's interested in what budget's doing. I'm happy to not attend that meeting so that one of you can attend it. We just have to, obviously make sure that we know who's coming so that we can work that out.
Absolutely, and that's kind of a hypothetical I had ready to go. There's a committee meeting, there's a subject matter one of you is particularly interested in. In the past, as Sarah mentioned, that's been an option of the chair sort of sitting out and then not making sure we don't have a quorum. And if far enough in advance, there's the possibility of potentially noticing that meeting accordingly. And in my point in kind of bringing this up is if you do see an item that's up for discussion in another committee, let us know, let me know, and then we can find a way to kind of make sure that you get the information you want. It's not just completely a dead end because it's a committee meeting, but there are sort of ways around where we can be in compliance with the Act.
I never considered that because at one point we were talking about something in enforcement And I wanted to attend, and Martha, y'all wanted to attend, and so we could have made that happen. We just would have had to treat the meeting in a different way. Is that correct, Kat?
You know, potentially, it's some sort of a scenario that I wouldn't want to happen very often, just because of, you could see how tricky things
Sure.
can kind of come up with the act. But you know, I think our workaround, you know, potentially would be, as you mentioned, you know, sitting out, and I think we actually might have recorded that meeting and posted it online to offer that. So I think my point is just like, you know, if there's something that you think you want to be a part of, or we're going to run into trouble with the act, let me know, and we can still try to find a way to work around it. So any other questions on that front? So back to closed meetings and executive session. So like I said, there was sort of very limited subject matter of what can be discussed. One of them specifically is, you know, consultation with an attorney, where you're seeking advice on pending litigation, contemplated litigation, you're considering settlement offers, and really a matter, how it's defined is sort of a matter that requires an attorney to comply with the rules of disciplinary conduct, which is essentially is that attorney-client privilege. If you're asking about legal advice, that's all fine to have in executive session. And, you know, that makes sense, right? You don't want that necessarily to be in the public. It still protects the agency's interests. I think another topic is sort of certain personnel matters potentially can be discussed in executive session. So it's pretty narrow. And Sarah, you probably know this is another area where you'll hear me pipe up and kind of redirect the conversation and make sure that we're staying in line with this, because there are consequences to being in violation of the act. Some of them are, there's criminal penalties, there's civil penalties, and also, you know, we talk about the criminal courts, the civil courts, but so there's also the court of public opinion, which, you know, you don't need a lawyer to tell you about why that's important, because that goes to, you know, the integrity of the agency, people being able to rely on what's being done at the agencies being done open and in compliance with the law. And so that's, again, this area I'm really trying to focus on, because this is one of the ones where, as opposed to rulemaking, where there's sort of a process of getting that training and getting a guidance on the law as you go along. Here, you know, we're in a meeting right now, and, you know, things can shift very quickly. If you're in a situation that doesn't seem to be a meeting, it could turn into a meeting very quickly. And, you know, just, this is really my, like, I want to make sure we're on the right side of this. So one of the things specifically I wanted to bring up, I'm going to share another statute with you all. And this is section 551, let's see, 551.143. And this is sort of the statute that kind of covers this walking quorum issue, where, you know, it's a series of single communications that become, you know, deliberation of a quorum, that there are, as it gets here, penalties for. There includes jail time and then a fine, or both. And so here I'm going to go through the statute a little bit. A member of a governmental body commits an offense if the member, 1, knowingly engages in at least one communication among a series of communications that each occur outside of a meeting authorized by this chapter, and that concern an issue within the jurisdiction of the governmental body, in which the member engaging in the individual communication constitutes fewer than a quorum of members, but the members engaging in the series of communications constitute a quorum of members. And 2, they knew at the time the member engaged in the communication that the series of communications would involve a quorum and would constitute a deliberation once a quorum of members engaged in the series of communications. So it's basically this situation of, you know, each individual communication in and of itself is not a communication amongst the quorum, but when you string them together, it becomes, deliberation amongst a quorum. And this, we went back through that definition of deliberation. It's not just being in person talking, it's also written. So this can happen combination of email with conversations. There could be something as innocent as forwarding an email, which again goes back to do not reply all, check your emails, count the number of people on your emails, count yourself on the emails if you do, and make sure we're not running afoul of this. Does anyone have any questions?
Kat, does that involve text messages as well? I believe it does, right?
Yes, written communications includes text messages, includes email. Correct. All right, so I'm going to unshare. All right. So biggest takeaways is, it may not be, it may be intended to be sort of a social gathering, but it could flip very quickly to something that needed to have been noticed as a public meeting, and be cognizant of your communications. It counts verbal as well as written. And if you have any questions, feel free to reach out to me, email, telephone, and, you have a resource to make sure that we're all in compliance with the Open Meetings Act. So I'm going to move on to our Public Information Act, which covers public documents. And the biggest thing here, and this is on page 18 of your materials, is that your emails, your text messages, all that's subject to a public information request. Now, it doesn't make a difference if you're using your personal or your work emails. If you're talking about public business, that's subject to a public information request. Now, I want to distinguish this. It may be responsive to a public information request, but it doesn't mean that it's ultimately going to be released, because we do have some exceptions that still apply. You've got your attorney-client privilege, and there still is a deliberative process privilege that can potentially protect your emails and your text messages. Sometimes they'll kind of carve up an email where, if you're include an attachment that has been publicly made available, that part will be released, but your actual discussion or legal advice, that could be withheld. And so, if you ever get requests on your personal emails, just let us know, and let Dion know, and we can kind of address it from there. Because in order for us to raise some of these exceptions, there are timing issues of when we have to raise them. Otherwise, they could potentially be waived. So that's all I really had to say on the Public Information Act. The next sort of section I wanted to cover is, there's a great bit of detail in our guidebook already on page 25, and this is sort of that conflicts, disqualifiers, recusal. And so I'm actually I'll go ahead and share my screen on this one too, since I'm kind of going over or following the guidebook here. Can everyone see that okay? Do I need to increase it? Or if you have your own, you're following along on your own. A lot of these initial financial disclosures, you would have taken care of this at the beginning of you joining, and Dion's the best at making sure that everyone's square with turning in all these required forms. On this conflict of issues here on 1.82, this is really goes to items that would have originally disqualified you from being board members, and that's acting as an officer or employee or paid consultant of a Texas trade association in the field of either real estate brokerage or appraisal, or your spouse doing that. And then again, if you are someone who needs to be registered as a lobbyist, again, in the same area of activity, profession related to the operation of the board, that is disqualifying. This next section here is really kind of covers situations where you'd be involved with a contract procurement, either for goods or services with the board. The biggest takeaway is if you or your family member might be involved with sort of contracting with the board, let us know, because typically, I mean, it would end up being that you can't be in a contractual relationship, or, you know, here you sort of have this, how close of a familial relationship can you be involved? Let me know. I mean, there's rules about your grandfather, uncle, cousin. Just let me know and we can kind of go through it. I think this is one of those areas that's pretty fact specific, but it really is just to put you on notice to issue spot if there's sort of a contractual relationship with the agency, with you or your family, or just let me know and we can kind of take it from there. Again, here, this is more like any financial interest you might have. It sort of defines what financial interest means. You don't have to own something, but you could potentially. And again, if there's anything here that rises to a level where you think this might be an issue, just let us know and we can kind of, we'll circle back and kind of talk it through. This next section, it's pretty straightforward. Don't be bribed. Don't offer to be bribed. Don't exchange your acts as, you know, your power, or exchange things or goods or solicit favors in exchange for anything that has to do with your role or your powers as a board member. I think that's pretty straightforward. I think we all knew that was illegal. So I don't anticipate we'll have too many questions on that front. Next I had here, this is one that's probably a little more applicable, might come up more often, is if a board member who has a personal or private interest in a measure, proposal, or decision pending before the board shall publicly disclose in an open meeting and shall recuse him or herself from deliberations or decisions on the matter. You know, the definition of personal or private interest, it sort of can vary. It's sort of factual based. So if there's anything that you think rises to the level of, you know, there might be a conflict or, you know, this involves someone I might know, just let me know and we can kind of look at it specifically if that ever comes up. And again, here, this is just bribery is illegal. All, you know, don't be bribed. Don't ask to be bribed. Does anyone have any questions? Okay. So sort of the last area of law I kind of want to cover was the area of antitrust and as it applies to us as an agency. So, you know, if you're familiar with sort of antitrust laws, we kind of went over this a little bit at the last meeting when we went over the governor's regulatory compliance division and sort of their role in making sure that we're not running afoul of any of these antitrust laws. Just to kind of back up a little bit and have a little bit more context, you know, you think of antitrust laws applying to these big conglomerates. You know, historically there's been the oil industry, or you think of AT&T, trust busting. That's normally what you think of. What it really boils down to is sort of having an anti-competitive, anti-free market sort of effect. And agencies, you know, those laws apply to agencies as well, not just the private sector, but also agencies. And so at the federal level, we have the Federal Trade Commission, which is the agency that's really tasked with monitoring this type of behavior. They file lawsuits against private companies, but also against state agencies and governments. So we've got the antitrust law running kind of concurrently with another legal principle, which is sovereign immunity, which is the general understanding that the government or governmental agencies generally can't be sued unless you are given consent. And so the interplay, you know, there's a lot of case law out there that sort of developed these tests to see whether a rule is okay, it's not anti-competitive, or maybe it is anti-competitive, but it's pursuant to legitimate interests, and there's all these other check marks that are boxes that are checked that make it okay for you to do that. Probably the more recent case that really spells everything out, and I've probably mentioned this before, but haven't really gone specifically over the facts, is that North Carolina dental board case. And so this is a case related to a dental board that had been receiving complaints about non-dentists offering teeth whitening services. You know, this was something that wasn't specifically addressed as dental practice, and a lot of the complaints were coming in because these non-dentists who were offering these services were offering it at a lower price. And so as a result of all these complaints, the dental board in North Carolina started issuing cease and desist letters to these non-dentists offering teeth whitening services. And a lot of these non-dentists ended up stopping their operations. And as a result, the FTC went and filed a suit and said, dental board, you can't do that. You're having an anti-competitive effect. And so the kind of case law that's sort of the rule, if you will, just sort of taken from this case is that, you know, an action taken by an agency can have an anti-competitive effect if, one, it's done pursuant to state policy, legislative authority, and two, that activity by the governmental body is actively monitored by the state. If those are all satisfied, then that state can claim immunity from suit. Some of the things that the Supreme Court brought up in this case that they pointed out specifically that I think is relevant to our agency is the fact that the North Carolina Dental Board had what they referred to as a controlling number of members who were market participants. A controlling number of people on their board were dentists and members of you know, the occupation that is being regulated. And so because of that, they pointed that out specifically as why there's a little bit extra scrutiny on agencies that are controlled by market participants than there would be if it hadn't been, or if it hadn't been a occupational agency specifically. You know, we have other agencies that aren't controlling licenses. Like if you think of TCEQ, the Texas Environmental Quality Commission, they are regulating sort of a statutory scheme, an area of law. It's not specific to a profession. Whereas here we are really regulating a profession and the activities of those performing that profession. And so that's one thing that we need to keep in mind as an agency is, you know, it's set out to, we have 4 public members and 4 appraiser members, and then we have an ex officio member who happens to be an appraiser. So the numbers sort of show that it is being controlled by market participants, but there's also case law that I've read where, you know, the numbers aren't dispositive of controlled. You can still potentially have control if, you know, it was completely equal, or you didn't have a majority of members who were appraisers. And I mean, I think what this case also sort of illustrates is that actively being monitored by the states. We have the governor's regulatory compliance division that is monitoring our rules. One thing that North Carolina case is, it wasn't a rule that got the agency in trouble. It was the cease and desist letters that they sent out. So while we do have this mechanism of being actively monitored by the governor's office, there's also other activities that we could do. You know, these cease and desist letter, I think that's a good example of, it doesn't have to be a rule where you can get in trouble, and you're not necessarily being actively monitored in the same way, or there isn't like a structured sort of system to monitor it. So again, this is really just something to be mindful of as we go on, that this may be an issue, and there's a little bit of extra scrutiny because of that being controlled by market participants. Stephanie, did you have a question?
That reminds me of the situation we had where in the banking industry, where there were people doing evaluations at a much lower price than our appraisers could do them. Does that antitrust law does that particular situation have anything to do with antitrust law? Or you know, as far as our approach on that topic?
Potentially, you know, I'd have to look at the specific facts of that, but I think that's an example. I mean, I think I could kind of see the parallels between, you know, teeth whitening, not exactly dentistry. I mean, it's a little bit different that I'd probably have to dig into a little bit more because, you know, I don't know what the North Carolina statute said specifically, or how loosely you can interpret something to kind of encapsulate teeth whitening versus our statutes, and how closely does that track with an evaluation, you know? And so, but I think it's very similar issues. um, that is raised, or that's sort of a good
I don't
example.
think we were proposing, I would have to go back and look at it, but I don't think we were proposing stopping the evaluators from doing the evaluations for the banks. I think we were more looking at how can we do the evaluations at a lower price.
Right, and I think what the North Carolina case was, there was sort of an action by the board that was stifling sort of market activity. Whereas maybe the issue is a little bit different of not stifling, but how much it involved, or what's the role. It's sort of different, slightly different legal questions, but again, you know, this is one of those things I think with agenda items, you know, this is a workshop, we're kind of generally talking about general concepts and less specific issues. That's more for a tomorrow type discussion. But I think that that's a really good example that you raised that kind of illustrates that that interplay or where it could potentially come up. But the thing that to keep in mind, I think, is that asking that question of like, are we being anti-competitive or are we making more of an open market? Because I think that's sort of a threshold issue of where you're going to have a problem. If we're stifling the free market, then that's probably where this case is going to come up. But if we're not, you know, when we've talked about lowering barriers, that's going to be less likely of an issue.
I definitely think we're opening the market opportunity. I just didn't want it to be seen the other way. Yeah. Thank you.
Yep. Anyone else have any questions? All right. So this is all I really had, I wanted to touch on for this workshop. And really that goes to, these are the things that I think are probably, you're going to get less training as we go along or less guidance as we go along on these type of issues. And it's things that I think it's just helpful for you all to be mindful of. And so, you know, if you have, I'm not one to have questions in the moment as much as I am to kind of sit and let things marinate and they come to me. So if you're like me, feel free to email me and reach out to me if you have any questions on anything we've gone through. All right. Well, that's all I have for item 3 on this one.
Okay, and then, very good. So then we can move on to agenda item number 4, overview of sunset changes. And is that you as well, Kat?
And you'll be hearing from Tony for the rest of these items.
I thought Tony's our sunset guy. I thought it might be him.
Good morning, board members. Tony Slagle, Deputy Commissioner. I wanted to just for the sake of those people who are on the board who weren't part of the process earlier, just briefly explain what the sunset process is. So every state agency has to go through a sunset review process, and typically that's every 12 years. And what that entails is there's a sunset commission, and they have a staff. They come in, they start doing an audit. They look at various things. They prepare a report. They provide it to the agency. The agency looks at it, is able to provide a rebuttal to the report. Both of those things are considered. Then there's a finalized report, which is presented to the Sunset Commission, which is made up of House members and Senate members and 2 public members. I think it's 5 House, 5 Senate, and 2 public members on each side. And that's all done prior to the session. And then when the session comes up, there is a sunset bill that is filed that deals with any recommendations made by the commission at the time. It basically makes statutory changes that reflect what the sunset report stated. And the reason that's necessary is because the way things are done in the state of Texas is state agencies have a lifespan. They have a date certain, which if that date is not changed, then the agency could possibly be sunsetted. So that process is necessary in order to move that date up another 12 years. We went through this process last session, and not a secret the sunset report wasn't the most favorable report that we could have gotten. As a result, we are on a truncated six-year schedule. That's always subject to change. The legislature could possibly change that based on our progress, based on other things, but you never know. But as of right now, that's a six-year process, which means likely if that stays the same, we would start the process over again towards the end of next year. I just wanted to give that overview.
For it to change, it's a statutory change, right? For that date to change, doesn't it have it? Okay.
Yes, ma'am. Yes, it's a statutory change. And I'm not saying that that's going to happen. I'm just saying it's always possible because they move dates around constantly. I know that TDLR, which is going through sunset currently, I don't think they've gone through sunset in 14 years, 16 years. They kept moving them around. So it happens. It just depends on a lot of it depends on how they feel the agency's doing, and also what the bandwidth of the current makeup of the reviews are. So if they have a lot of reviews, they might move things around based on that. But that's what they.
But they would have to do that if it's a legislative change for the date. Then they would have to do that 2 years ahead, right? So we would know. I mean, it wouldn't be just like all of a sudden we get to that 6th year and it's like, yeah.
No. That would be a legislative change. And there's always a bill. There's a scheduling bill that they file every session. That's likely where something like that would happen. If it were to happen at all, would be in that. They wouldn't they would unlikely open up our statute to do that. They would do it in a scheduling bill.
And Tony, just so I understand, so we're saying that we went through the prior sunset process, and they've given us a time frame to clean up. And you're saying that we are going to hit the next sunset process, the new one next year?
Well, the beginning of it. So it'll be because they have to come in early and start doing the review. They'll reach out to us. We'll have meetings. It'll be the beginning of that process will likely start towards the end of next year, beginning of the following year. Because they need to have time to come in and start auditing and looking at stuff. I just wanted you all to be aware of that the truncated 6-year schedule puts us on all of that is truncated. So it's likely to start end of 2021, beginning of 2022.
Okay, so we need to make sure that we are completely on point with what they wanted in the first review by that time. So that when they come back the second time, we hopefully can completely change the way our image was out there.
And if we fail, Tony, we're putting it on your shoulders.
That's fine.
Well, that's perfect. I was hoping you would say that.
Yes, that's fine.
I'm kidding.
But I did want to let all of you know, if you haven't seen it, last Friday, that was sort of the end of this current review process in terms of our reporting on the overall compliance with the sunset recommendations. The good news is most of that we've complied with most of that fairly early on. There were a couple of things on the commission side we needed to finish up, and we finished that up this past spring. And this summer we hit the time frame that was recommended or required in terms of complaint resolution on the board side, which was I believe 180 days. We hit that. So the good news is that report that we sent off shows that we're in compliance with every recommendation that they asked for. And what will happen next in terms of that is there'll be this coming session sometime in January, there'll be a Sunset Commission hearing. I don't have the actual date. I tried to look on the website to see if they have it scheduled, and they haven't yet. But there'll be a Sunset Commission hearing where they'll wrap that up, that review up, and they'll use that document and any supporting document that we sent over them to talk about our compliance and where we are. There is some ongoing reporting that we have to continue to do for metrics. The last quarterly report will be due this December. So we've had since the bill went into effect, we're required to report on a quarterly basis certain metrics, and that last report and that deadline is January of 2021. So the last report we'll do will be for December. We'll submit that in December. And then there's an annual report that we submit every January. We did one this last January, and that goes through 2023. So we'll submit one, this upcoming year and then the next couple of years in January, which reports that data over a yearly basis. So that'll be for the next couple of years, but the quarterly reports will be stopped or will be completed by this December. I didn't know how deep a dive you wanted to get into the sunset stuff. I mean, I'm happy to answer any questions or address any issues you have, but with your guidance and the guidance the commission staff's done a lot, and we've worked really hard and gotten not only compliant with all of those things, but we you can see the progress the agency's made over the last several years in terms of our metrics and what we're doing. We've implemented a lot of things to get us where Sunset wanted to be, and to a certain extent even better, I think. So I think in terms of all of that stuff, we look good and we're in good shape.
And I think I've asked this question before, but obviously Sunset can only look at what's quantifiable, right? And so there's a certain number of things that, as Stephanie said, have to be on point that we want to make sure. So I assume that now, obviously they focused on the hold times, and that was a huge deal. So I just want to make sure now that we've got that under control that they're not going to focus on something else that we didn't consider that they were going to focus on. So maybe, I would assume we watch what other agencies, and as the makeup of the Sunset Review Commission changes, they probably focus on different things. And so are we kind of keeping abreast of what their current thing is? It's kind of like bank examiners, right? Like one time they focus on appraisals and then they don't talk about them for 6 years, that, on every time just depending on who it is or what's going on in the marketplace. So I just want to make sure that we've covered all of our bases.
Yeah, we do monitor that. There's always, for lack of a term, what's called universal sunset language that's applied to all agencies. Because we so recently went through that, we're sort of on that same pace that they're adding to other agencies. This training that you're going through right now is one of the things that is kind of the universal sunset thing, is that board and commissions go through this training. So the works that you just went through in the workshop. So that's one of the things. Another sort of general thing is, the residency requirement, which didn't really impact the board as much as it did the commission, because there wasn't really one outside of the trainees, and that was removed in the statute. So there wasn't anything we needed to do on that other than update some forms and some website language, but that was already implemented. And there are other things that, sort of what Sunset looks at just in general. They have sort of a template. This is what we want all agencies to kind of comply with, this particular stuff. And then they go into the sort of nitty gritty details of other things that are specific to that agency. I'm sorry. I was just going to say, we have a really good relationship with Sunset. I know that sounds odd, but we do. I have a good relationship with the staff over there. I talk to them, off and on, mainly because of the quarterly reports. But so that helps because we can ask questions going forward as well.
Can you send us a list of what they will be looking at? Like you said, they have kind of like a list that they go through.
I'd have to get that through Sunset to see exactly what their kind of statutory targeted things are. I can see if I can pull that up.
I appreciate it, and that just helps us kind of start preparing in advance of their visit.
Yeah, and I don't know if that's something that they share publicly or not, but if I can find it, I will definitely send it to all of you.
And then the other thing I would say that I think we need to pay attention to, and we do, is what is the public saying about us? What are the overall complaints? Are there any repeated complaints that we're hearing? And then those same people will testify before Sunset to say, here's what's wrong with the agency. So we want to make sure we have a handle on that, and that we, because we want to be good public servants, we want to address those concerns as quickly as possible, and of course not wait for Sunset.
Mm-hmm.
But that's anecdotal, but that's my approach, is keep your ear to the grindstone on what Sunset is doing in other agencies, and also make sure to have your ear to the members of the public and those we
Right.
serve.
And as Chelsea said, that's not something that's something we do ongoing anyway. If we see patterns or we see issues, we address them, because it's not something you wait around to do. You try to address them as we can find solutions for them. So hopefully by the time you do go through another sunset audit process, those issues have already been taken care of, or they're few and far between.
And I don't know if this is the proper form to do this, but that brings up a great question, Chelsea. So how do we do that? How are we? I know customer service, I'm sure we're monitoring any complaints coming through there, but it's kind of hard to do, I guess, town forums to get feedback from different sectors, different regions. But how do we make sure that we are listening and then we are getting soliciting information from our stakeholders to make sure we are doing a good job?
That's a great question. I think Tony may have something to add to this. I would say in a number of ways, data is very helpful. What are our processing times? How long? I mean, of course, call hold times. That's one that we know that we'll never be bad again on that, because it was such an issue on this last go round. But then also, anecdotally, we stay in very close contact with our customer relations leadership. So, and whenever they're hearing repeated questions or repeated concerns, that gets to Tony and I, so that we can really, for a number of reasons, to address those concerns or issues, but also that helps us manage call hold time, right? If we can address that issue globally, then we will receive less calls. So I think it's being in tune on the soft side, and then on the more data-driven side, I think it's paying attention to our numbers and staying nimble enough to address them.
Okay.
Yeah,
Hey,
and
Stephanie, one thing I would point out too is that I think in almost any instance where there's communication between the agency and others, they are invited to take a survey and give us feedback. And I think we talked about this before, but every Friday I get the enforcement division feedback. And so that allows us the opportunity to actually see what people are saying about their experience, and whether it deals with an enforcement action or customer service, we have that opportunity.
Okay, so you get it from the enforcement side of things, and who's looking at it from the licensing, application process, education?
So any communication as Mr. Bolton said, any communication that comes through the agency, we do send a survey out to them. Robert, who's the head of the contact center, he gets that information and reviews it, puts it together. I report on it every month to you guys in my email as to sort of where we're going with that. It's a general, it's not drilled down to stuff, but one of the things they do in looking at that is to see if there's any patterns. Okay. Also they do that when we get calls. If there's something where we get 2 or 3 calls in a row, or one day, and it's the same issue, then Robert puts his staff on notice that, hey, we need to monitor this to see if this is a bigger issue or not. Because you don't want to overcorrect and spend resources on something that's not a problem, but you also don't want to ignore it. So you monitor it to make sure. Maybe it was just 3 calls and that was it. Maybe it's 30 calls. So we do that. And then one other thing that we did as an agency this fall, and we do it every other year, is we go out and, we didn't really do it because of the pandemic, but we go out and reach out to stakeholders and we travel around the state and try to get input that way as well. That's usually part of the strategic planning process, but we do that, also to get in touch with sort of what are the issues out there that people are concerned about. And then just something as simple as, routinely in our newsletters, encouraging to get involved as much as possible, because it helps us know if there's issues, and it helps you guys know, what the feedback is. So
what about the big associations? Have they sent in any feedback on our performance? I know sometimes they'll speak up during some of the meetings we have, committee meetings or board meetings, but throughout the year, do we ever hear from the association groups on how we're doing?
Well, we have a fairly good relationship with FACT.
Right.
And so we meet with them occasionally. It's not usually typically on those particular issues, it's other things. But you know, we have a good enough relationship to where they can reach out to us anytime and address those things. And if we need to have a more formal communication, we can do that. We can get data for them and have a conversation, which we've done in the past.
Okay, thank you.
Okay, one thing I was going to add was in the past, we have had those town halls, you know, and Christine and the former commissioner went to, you know, around and talked to everybody. And I don't know how helpful those particular ones were, but there, you know, there are ways to reach out, and we have done that.
That's a great point, and that's one that Chair Oates, we should probably talk through. We did do that on the commission side, this all remotely, and we can do the same on the board side. It was important to me that those be separate because we're not traveling, and the content is it's just different. And I think what happened, I have never attended, so this may be completely wrong, but I think what happened in the past is that they were combined and focused on the commission side. And so then the appraisers were somewhat slighted. And so I'd love an opportunity to do some of those, just to hold just a remote session or two where we say what's coming up and provide an opportunity for folks to raise questions and issues. And what that does is it keeps a running list for us on, it allows us to know what is repeated and therefore what might be systemic, but then also just know how we can address concerns and issues.
I think
Well,
that's actually a really good idea.
I think that I sure hope that this traveling is not being able to travel in Zoom meetings is not goes on too long into the new year, because it's so great to have that conversation. And we had good conversations in person. And I just don't want us to get into that method. Well, it's even easier and less costly to just do a Zoom meeting, but it is certainly not a replacement for looking in someone's eyes or someone saying, well, I'm going to go and I'm going to have something to say, and to hear just how forceful or how meek they feel about it.
Absolutely. In fact, I think it might catch different people if you were to do a combination of both.
Absolutely. Definitely. Well, and I will say that I never attended any of them, but I do know from when the Commissioner Old Mixon would come to FACT that it wasn't a let me hear from you. It was more a let me tell you how awesome the agency is and how great we're doing. And that's why I think Sunset took everybody by such surprise, because all we had ever heard was how great everything was. And so I think, the tone of it is important as well, and not to just come and say, we always heard about how enforcement was kind and gentle, and then we were hearing all this other stuff. And so it was like, where's the disconnect here? So I just want to make sure that when we do this, when we do reach out to stakeholders, that we aren't just talking to them and telling them how great everything is, that we really provide an opportunity for them to air whatever their grievances are. Because a lot of people just won't reach out because they think they're a small fish in a big pond. And so if we can give them that opportunity to do that, I think that would be fantastic, whether it be both in person and Zoom. I hope that we will always offer the in Zoom, because I think there are a million appraisers out there that would log on and spend 2 hours where they wouldn't spend 6 hours driving and doing all that, but that they would like to be part of the process. So I think that would be great. Another question that I had about Sunset is, I know that because we're an SDSI agency, that they're on the accounting end, that there's probably a different way that they look at our books and that sort of thing. And so my thoughts earlier on the makeup of the Sunset Commission is, of course, our legislators all have regular day jobs. This isn't their job. And so if we got an accountant, say, that was on the review, I just want to make sure that we're prepared for all of that. And I assume that that's something that Renata keeps up with, and we'll watch this year's sunset hearings and that sort of thing so that we stay on top of that, because I know that that is an area that we could be dinged for, and we certainly don't want to lose that status. So I want to make sure we focus on that as well.
And we are, and I think that so FDSI is something that the legislature still is, struggles with from time to time. But I do think that they, in terms of general accounting principles and the things that they look at, a lot of those were referenced in our last sunset review, things that we need to do better on, that we have done better on. And we have policies in place now that, that you, the board, have approved for, and the commission has also approved. So yeah, I think we're prepared for any of that.
Fantastic.
I am happy to anyone. I know this is, I don't want to extend this meeting, but if anyone has any questions about what I sent on Friday, please reach out to me. I'm happy to provide more information or more detail on any of that stuff.
We're good. So Tony, are you handling the next one as well, legislative overview? And let me ask before, well, you can go ahead and answer that question.
I am, but go ahead. I'm sorry.
So do you anticipate this to be an in-depth discussion? Because I want to give everybody a break to grab a cup of coffee or something if necessary.
It depends on, I was just going to present what we talked about in the executive committee with a couple of other items. Well, then I
think we can go through. Is anybody needing a break right now? I'm happy to call a 5-minute if Martha Gale, I see you looking at me. You're on mute. You're on mute. We can't hear you.
Lola just has to go outside. I'm sorry, but we'll go whenever.
Anybody else? Okay, then we'll keep going so that maybe Clayton can get out of here on time. And Clayton, just wave your hand if you need to go.
Yeah. Thanks a lot, Sarah. I'm still good. My buddy just landed at the airport, so he's another 20 minutes away, so I'm fine.
Awesome. All right.
Okay. If it's all right, I'm going to share my screen just because. Okay. Can everybody see that? Oops. Sorry. Trying to make it big enough. Can everyone see that all right?
When you scrolled in, it was better.
Is that good?
Yeah,
I can move it to, okay. I can move it to another screen. I've got two screens going and one of them. I'm sorry?
I'm asking Stephanie if she can see.
Sorry, I was on mute there. Yes, ma'am, that looks great. Thank you for checking.
Okay, so thank you, everybody. Again, Tony Slagle, Deputy Commissioner. These are the possible legislative priorities for the next session. Staff met with the Executive Committee to go over some of the items that staff had come up with based on some discussions that have happened since the last session. And these top 3 items were the ones that were discussed and for consideration to move forward. Tomorrow at the board meeting, there'll be, if everyone's okay with these, there'll be a formal movement to direct staff on what to do in the upcoming session. But essentially, there is the amend the confidentiality provision to add supervisory appraisers. Currently, there's a list of people who are exempt certain aspects of the confidentiality provision, and supervisory appraisers are not on that list. There's been a concerted effort to communicate more with them on various aspects, and so this would be part of that, continuation to do so, but there needs to be a statutory change to add them to that list in order to make that happen. The next one is, of course, the language about evaluations, and this is simply to clarify it. I will say that I did meet with FACT yesterday to talk about some of this, and it's likely they're going to file something as well to deal with this and address what their concerns are. So that may be where that goes. But again, we have a good relationship with them, so we will communicate throughout that process. And then the third bullet is to expand the jurisdiction of the peer investigative committees to encompass more than complaints. Currently, statutorily, they're limited to looking at complaints, and that would just give the board an additional tool in the toolbox in doing some of these reviews, particularly audits, which PIC members are not statutorily specified to do. And then before I answer any questions, there are two possible other amendments that I apologize did not come before the executive committee when we discussed them. One of them is to possibly receive authority to allow fingerprinting during a fitness determination, and what that would do is early on, if someone wanted to know whether or not there's anything in their background that might prevent them from being licensed. Right now they can pay $50 and we can review it, and then when they go through the licensing process, they get fingerprinted. This would remove that initial fingerprint or that initial process for fitness determination and the $50, and just go directly into the fingerprinting process, and then we'd have a repository where we'd keep that information. So once they formally applied, we could go back to that and look at it. And then the second one is to give the agency the authority to fingerprint employees who deal with sensitive information, credit cards, social security numbers, bank accounts, that sort of thing. Again, we don't currently have the authority to look at an incoming person's background to determine if there's anything in it that might, call to question whether or not they should be hired for a particular position. I will say that the legislature has always had an issue with fingerprinting. And because of the bandwidth of certain things going on with the legislature's bandwidth this session, those two items may not be anything that, we want to move forward with. If there's any controversy, it's likely they're not going to go anywhere anyway. But I did want to bring them to your attention because the commission has directed staff to move forward on those to the extent that they're not controversial, and just to, if there's consistency on how we apply these things, we might want to look at adding both of those to what the board's doing as well. And I'm happy to answer any questions about any of this.
Anybody have any questions? So again, we'll see this tomorrow. Go ahead.
I'm sorry, Tony, did you say this was in our material or no, or not?
It should be in your materials for tomorrow because that's when the board's going to actually deliberate on it and determine what they want to direct staff to do with them.
Okay, thank you.
So yeah, this is just to give, if there's needed to be any in-depth discussion to have on any of these items, so that when they come up before the board tomorrow, that discussion's already been had possibly, and you could just move forward in whatever you want to do. I mean, you can still have the discussion tomorrow, but that's why they're on the workshop as well.
I thought that we didn't have them in, let me just confirm that we do have them in tomorrow's board materials, because I've kind of gone through it and, oh yeah, okay. Oh, so we do have the 3 bulleted points. Maybe you already said that, Tony. And
yeah,
then,
it's the other two sort of came about after we met. And again, I just wanted to bring it up because it was part of the discussion on the commission side. And in terms of any, the things don't have to be the same for both, but just that there was a desire to be consistent. I just wanted to bring it to your attention.
okay. And so tomorrow, when we discuss this, if we want to add those 2 other points, we can just mention that as part of the motion.
Yes, ma'am. And again, understanding this is an odd session, and we want to make sure that that there's the least amount of controversy or any sort of rumblings about anything that we go forward with to the any members, because they're likely not going to want to address it. They've got enough on their plate. They're not going to want to address anything that's going to be a hard sell. So.
And so, from your understanding, FACT hasn't delivered anything to Ledge Council or found a sponsor or anything like that?
No, they're moving towards that. Yeah, it's something that they're looking at, but I think things they were waiting for, because I'm in communication with them about this stuff off and on, and I think they wanted to just see what the direction of the board was going to be as well.
Okay.
And then Tony, on the last point of chapter 411, we're talking about our employees being fingerprinted?
Yeah, certain employees, not all of them, but depending on what the job description is, that would the process is that we would do a criminal background check on them to make sure that, you know, they don't have robbery or something in their
Sure.
background, or
Can you give me an example of what departments that will affect and what we are currently doing when we onboard someone in terms of their background?
I can answer the first question. I apologize. I don't have an answer to the second question, but I can get it for you. It would likely be the contact center because they deal with credit card information over the phone. We have people who handle money that work, you know, that open the mail and handle money. It'd likely be those people. Maybe a couple of people in licensing who deal with, you know, sensitive information. It's just to give everyone peace of mind that we're, you know, that we're hiring people of good, and there's not any indication that any of that's going on right now, but I apologize. I don't know what we do currently in terms of onboarding those employees.
Okay. Thank you for the additional information.
Yes, ma'am.
I would say the only thing that we do right now is we do reference checks on our employees, and then we provide them training on what our policies are,
Mhm.
which would include, this sounds silly, but things like only use credit card information for its intended purpose. And I want to say again, this has not been an issue. I'm knocking on wood as we speak in our agency. We have a very trustworthy team, but it is somewhat unusual not to conduct criminal background checks on folks who are handling sensitive information.
Yeah, thank you, Chelsea. That's absolutely right. There's not any current concerns about any of this. The people who do this are you know, there's not any issues whatsoever with any of that. But this was brought up mainly because there are other agencies that have this provision, and it's helpful to have when you're dealing with new employees.
And you can't fingerprint an employee without it in the statute?
No, ma'am. It has to be given a statutory authority to do it.
Wow.
You know, I'm thinking as we're talking about this, is this going to cause a barrier to employment for certain groups of people who may have a criminal background, however, they have served their time or done their whatever, and they're still wanting to be employed? So is it,
I think,
would this cause a barrier to employment?
It
I
could
think
be.
this would.
It's the reason why it would need to be very narrow in scope, that we would need to identify what would be an offense that would trigger
Yeah, okay.
some, and I mean, but yes, and I will say, I mean, I know that we have people in our agency with criminal history, and I love that. I love that we are an agency that allows for a second chance. We do not want to change that at all. But we do want to know what we need to know, right? And make sure that we're making decisions with the correct tension in mind, not creating a necessary barrier while protecting those that we serve.
And just to be clear, I'm all for the background checks, fingerprints for people who are handling sensitive information. I do think that that's important. And as a healthcare provider myself, we do those things. And so I'm all for that for particular positions. But I know that may trigger then the second question of, oh, well, this isn't, you know, a barrier for employment. So I just want to make sure that we as a team have a plan of action that if we go forward with this, then like you said, Chelsea, we limit it to certain positions, and then we limit it further to certain types of criminal histories that's relevant to that position, that's relevant for that position. Does that make sense?
I wholeheartedly agree. And I hope when we have this discussion tomorrow, Stephanie, I hope that you'll reiterate those concerns, because I think it's important for our stakeholders to know that that's the way that's how we want this agency to be.
No barriers to building up the economy here in the state of Texas, including housing.
But I just want to reiterate again that, you know, fingerprintings are a sticky issue with the legislature, so it may not be even it's something we want to move forward on. Just depends. You know, obviously we can get some feedback when we approach somebody, and if they're like, oh, then we're like, okay, it's not ripe right now.
But yeah, but I think it's a great idea. And you know what, if someone's handling my credit card information, I want to make sure that they've been vetted. So I definitely think it's a great idea. I just want, but I think we also have a great plan to make sure we be specific on how to roll that out. But no, I don't think we should shy away from it, even if people are kind of not wanting to touch it right now. I think it's a great idea, because I would want someone, to handle my financial information that had been vetted.
I would say that our overall approach for this legislative session is to have these items I've said this to Tony many times, in our back pocket for use and to move forward on as it seems necessary, knowing that it's almost impossible to predict what may be appropriate and necessary in this session. Every session is unique. There's a uniqueness to this session that goes beyond anything I've experienced, so that we just don't know what to expect. So this is a session to be maybe in more of a defense posture, but to provide opportunities to work with legislators as they would like to on certain issues, but maybe not the time to do much more than that.
Very good. No more questions for Tony? Very good. I think that wraps up then agenda item number 5. Moving on to agenda item number 6, request for potential workshop agenda items. I will pause, and I don't, Kat, we didn't have, Mr. Bolton had asked if possible, could we have an executive session today? We don't have that on the agenda, correct? I don't want to go into executive session because I know that he wants to talk about pending litigation, and I want to make sure that Clayton hears that whole conversation. So I'd rather do it tomorrow, but I just want to make sure that's not even an option on our agenda, is it?
No, I mean, executive session's an option always, but I did plan on providing an update on that tomorrow in executive session.
Okay, so are you agreeable to that, Mr. Bolton? Because I know that Clayton is leaving, and I know that he also wants to hear, what's happening with any potential litigation. So
Yes, I do.
Yeah, no, I'm fine. That's fine.
okay, very good. Okay, so we will have that discussion tomorrow in executive session.
Okay.
Okay, so back to item number 6, request for potential future workshop agenda items. Is there anything that anybody would like to cover? And this is Rolando, this is always kind of an open, ongoing thing as we go through different committee meetings or different things happen. We'll go, let's talk about that. We want to dig into that more. Let's talk about that at the next workshop. And this one was a little truncated because we're doing it virtually as opposed to in person, where it's a little easier to get everybody in the room and kind of dig into stuff. So this one is probably shorter than most have been or will be, but that's an ongoing thing. So if anybody doesn't have anything today to add for a future workshop, we kind of just keep an ongoing list. And I've asked Dion also to keep a running list of what is covered in each workshop. That way, as the makeup of the board changes, over everybody's 6-year terms, that if it's something that hasn't been covered, it's going to be covered again sometime at the beginning of your term, so that we can stagger it like that. But it's always malleable. So hearing nothing, I'll move on to agenda item number 7, discussion and possible action to schedule future workshop dates. So we don't have a workshop at before every meeting. I think February is typically a time we do, knowing that we'll probably be virtual still in February. I would say unless it's a have to, that we don't have a February workshop, but that we try and have a May workshop if possible. Is there any reason why we have to have one in February?
No.
Okay. Is everybody kind of, Tony, would you mind unsharing your screen so that I can see everybody? Just get a visual cue from, thank you, sir.
Sorry about that.
That's okay. And so is everybody sort of generally agreeable to a May workshop as opposed to February? That works for everybody? Yes. Okay.
Chair, I think February's workshop is typically please, someone stop me if this is wrong, more of a budget workshop.
Okay.
It's the midpoint in the year, but that can be handled. We could just put on the formal board meeting agenda a more robust report on the budget. It's but it just allows y'all to have a clearer understanding of what's happening with the budget at the midpoint. But I just wanted you to have that info.
Okay.
It's not a reason for a workshop.
Okay. And I did have, as I was kind of looking through staff reports yesterday, I did have a thought that possibly Rolando and I could benefit from. So much with the budget was done before my tenure, and so and Stephanie and Lisa as well, obviously, that at some point, if we wanted to sort of dig into, you know, we had all those options of fee increases, and those are things that are taking place now, but we don't have the background necessarily for them. And so maybe if we at some point could create an opportunity for us to have just a discussion and no deliberation, more of an explanation type thing. But I don't want to include everybody. I mean, you know, Clayton has dug into the budget and into the minutia for years, and he doesn't need that background. So I don't want to, you know, force him to sit through it. So, so Chelsea, I'll get with you on figuring out what would work for all of that. Sound good for everybody?
I would like that, yeah.
Very good. Okay, so if there's nothing else, then we did this quick today, guys.
I was just gonna ask, Rolando, did you get a copy of the sunset report? I know Sarah sent it to me when I first joined the board, and it was so helpful.
I do have one, yes.
Okay, awesome. Just trying to. Yeah.
I've got a real quick question just regarding the logging on tomorrow. Are we going to receive another link, or do we use the same one that we had today?
You'll get new links for tomorrow. I didn't want to send you guys 4 at the same time. It's confusing enough as it is.
Agreed. I thought that was the case. I just was making sure. Okay, thanks for clearing that up.
Sure. Very good. Anything else? Okay, so 10 a.m. we will see everybody again tomorrow. I appreciate everybody joining virtually. And the time is 12:04, and this meeting is adjourned. Thank you, everybody.
Thank you.
you.
See you tomorrow.
Thank you.
Tomorrow.
Bye.
Hey, guys.